It's another beautiful outing to join us on Law and You. My name is Philip Omo Yupon, and we're going to be looking at the NAIRA note scarcity. And recently again, the Supreme Court gave a ruling saying that the 1,500 and 200 old NAIRA notes should continue to be circulated till December 31st. And you understand that there has been issues where even the Supreme Court heavily descended on the issue of the president's perceived disobedience of the order that earlier said from the Supreme Court that the NAIRA notes, the old NAIRA notes, should coexist with the old ones. But looking at it, we need to throw more light in this perspective, and we are having an array of legal practitioners to interrogate this. And starting from my immediate left, I have a legal practitioner, Sunday Daudu. Thanks for coming, Sunday.
Thank you very much.
And next to him is the former chairman, NBA Benin branch, Barrister Eddie Asenogwan. Thanks for coming, Eddie.
Thank you, Philip, and good day, listeners.
And of course, another legal practitioner in Barrister Emmanuel Edopolo. Thanks for coming.
Obakolo. It's a pleasure being here. Thank you.
And of course, another legal practitioner, Barrister Emmanuel Obakolo. Thanks for coming.
Thank you very much.
All right, let's look at this issue of the NAIRA note scarcity. You agree with me? We've been having this discourse, and there has been issues about the president who has jurisdiction, to interrogate this. Is it the CBN and the president alone, or does the judiciary come in to, interrogate this, where issues of clarity, need to be brought to the glare of the public or Nigerians? Now, just now, the Supreme Court made another ruling stating that the old NAIRA notes should coexist with the new one till December 31st. How do you feel this recent judgment as compared to the broadcast of President Muhammadu Buhari saying that only the 200 should circulate? Daudu.
Yes, thank you very much. Whatever argument we are going to canvass here now may be a post-mortem analysis, because the Speaker has spoken. Once the Speaker speaks on an issue, he is said to have laid the matter to rest, as to whether or not he has the power or jurisdiction to entertain the matter. That has been laid to rest. Okay. But as persons of legal minds who must interrogate the issue, the question is whether the judgment in itself is a judgment based on the competence of the court to entertain the matter. The answer is technical, but it is to the effect that the court relied on its inherent jurisdiction because the matter was a public interest litigation and not on the original jurisdiction of the court. Okay. Because when you say matter, you have to look at the premise upon which the Supreme Court give their judgment. It's on grounds that they have the competence to entertain the matter because the matter between states and federal government. That's not the law. The issue of currency regulation, monetary policy of a country, is not an issue that the state's government and the federal government are in dispute, to which the Supreme Court has jurisdiction. It's not contained anywhere. I have technically looked at it. It's not one of the issues that the states could be said to have a problem with the federal government to litigate upon. But the court may have viewed it from a public interest litigation, and that the state governments were acting for the interest of the public because there was a discord in society as to whether or not the policy was not ill-conceived. On that ground, the court has assumed jurisdiction. But if we must speak to the issue as to whether it's one of the issues that can be said to be a problem between states and the federal government, in which case the state have the capacity to institute the matter in the Supreme Court, I'm afraid whether it's such a matter. But I can concede, because when you are instituting a matter in court, we also come under the inherent jurisdiction of the court. The court has inherent powers to make public policy pronouncements in respect to issues that may cause confusion in the state or the country, for the purpose of the country. So under that ground, we can say the court assumed jurisdiction based on its power and based on the ground that the matter was a public interest litigation.
Okay.
In which case, the Supreme Court gave the judgment. Again, the question is whether or not the judgment is whether or not go to the policy of the CBA. The answer is also no. The judgment of the Supreme Court does not affect the policy of the federal government or the policy of Central Bank of Nigeria in regulating the NAIRA notes. What the Supreme Court judgment really did is to give allowance as against the deadline. Okay. Otherwise, the Supreme Court would have struck down the policy.
But what about the aspect of the redesign policy where reports have it that it said that it invalidated the design?
No. If that was the judgment, the court will not say the old NAIRA notes and the new NAIRA notes to coexist.
Okay.
That is not the judgment. Anybody who is giving that interpretation does not read the judgment. The Supreme Court said that the old NAIRA notes and the new NAIRA notes will coexist till December 2023. Which means that the policy itself was not voided.
Okay.
But what the court did was that the period given for the implementation was technically too short. I have argued that the period itself may not have gone down well with people. Again, people argue whether it was timely to institute it at the parallel of election. I said there was no best time for it. But what the court looked at was the public interest. Well, I told you it was failure of the central bank. What the central bank did that is leading to this litigation is their failure to make the new NAIRA notes available. If the new NAIRA notes were available, people go to the bank, you return your old NAIRA notes, and you get your new NAIRA. All these issues will not be there. It's the failure of the part of the central bank for not producing enough new NAIRA notes that leads to the issue. It's not the issue, it's not the policy. If I return my money, I get my new NAIRA notes back. What would I be crying for? It is the failure of the central bank not making the new NAIRA notes available that is leading to all this issue. If you go to the bank and you can't get money.
Let's take your reaction over this, because we've seen reports where it was said that the president, should have interrogated this process using the National Council, and being that it didn't do this, it invalidated, the redesign policy. Or how do you?
Yes, I beg to differ a little bit from my learned friend. The Supreme Court assumed jurisdiction. There was a preliminary objection challenging the jurisdiction of the Supreme Court to entertain the matter. The arguments were canvassed. First, that the central bank was not a party to the action, and secondly, that being a monetary policy of the central bank, which the law gives them power to do, it did not fall within the original jurisdiction of the Supreme Court. Before the Supreme Court gave judgment, the Supreme Court went into that issue of jurisdiction. Okay. And the Supreme Court said, well, look, the federal government itself is represented in that case. Okay. And that when you sue the principal of a disclosed agent, you don't need to sue the agent. And that the action was competent in spite of the fact that the CBN was not there. Yeah. The Supreme Court went ahead to say that it was not a policy the president could on his own, with a discussion with the governor of the central bank, just implement. That failure to get the Federal Executive Council and the National Council of States involved or carried along in the process where the issue would have been discussed and a decision taken on it, voided the decision. The Supreme Court also went ahead to say that the Supreme Court, the CBN, did not issue the required notice, a valid notice in law. By the provisions of the CBN Act itself. Yes. That the notice they issued, that the circulation in press releases and all of that did not qualify, in the opinion of the Supreme Court, as the notice required by law. And then the Supreme Court now came to the conclusion that even the process leading to the redesign of the NAIRA was invalid. Was invalid. Now, where the issue consultation was the procedure was not followed. Now the question is, if the Supreme Court, that's where I have an issue with the Supreme Court, not whether or not they had jurisdiction and all of that. If you have now declared the procedure leading to the implementation of the policy itself invalid, the consequence would have been that the design of the new NAIRA. Yes. Because the process and procedure leading to it have been voided and invalidated. But I'm sure that's where they now looked at it, the implication, of now saying withdraw the new Naira notes and all of that. Don't forget, while the interim injunction which the Supreme Court gave, that, oh no, until we look at it, let all the currencies continue to be in circulation. And then the president came, made an announcement to the nation, where he said, no, look, 500, 1,000 will remain not in use. I can only permit 200 Naira. That was an affront, a confrontation on the jurisdiction of the Supreme Court. Because we were altering the order of the Supreme Court.
Is the president bound to obey the orders of the Supreme Court?
Definitely. Every person and authority in this country must obey a final decision of the Supreme Court, rightly or wrongly. Once they have spoken, they have spoken. So the Supreme Court said, in fact, the Supreme Court addressed in its judgment that amounted to dictatorship and it negates the provisions of the rule of law. So, but again, the Supreme Court fell short of issuing a sanction to the president for voiding or violating his own order.
But the president has immunity, or does that not count?
It is contemptuous. Immunity in the sense that you cannot be prosecuted. Not that, certain pronouncement cannot be made.
Ground.
You dare not, because it can lead to a situation where Supreme Court has made a statement, Supreme Court has taken a position, and then the president says no. It does not augur well for our democracy. But because the Supreme Court just ended it there, but on the issue of the redesign, the Supreme Court again haven't said, oh, it's invalid, the procedure. What would have thought? Yeah. And now, don't forget, I got it on good authority, that even the federal government, they posted an affidavit before the Supreme Court, that the old 1,000 Naira and the old 500 Naira have been destroyed, which has fostered a fait accompli on even this decision of the Supreme Court, because what it is today, the law as of today, is that the 500 Naira, the 1,000 Naira, and the 200 Naira remains valid legal tender, which must continue to be used, although now side by side with the new ones until 31st of
Okay, let's take your bite on that, most especially as it also said that this violates the fundamental rights of the citizens because of the hardship that they have now been put into. What do you make of this in terms of going forward, and just like what has been said or reported about the 500 and 1,000 Naira notes being destroyed? What could be the implication of this?
Well, first and foremost, I want to align myself with my learned senior who just spoke. And also, if you look at, I want to look at it from this angle, because the federal government argued mainly on the provisions of the CBN Act, particularly section 20 subsection 3. That was where they gather their own argument from. But the Supreme Court, in its wisdom, came up, to my mind, with a very good judgment. However, there are some lapses, just like my learned senior pointed out. But looking at it, I think, to my mind, why, despite the fact that the Supreme Court voided the process that generated and that brought about the emergence of the new Naira note, so to speak, the Supreme Court the Supreme Court was careful, in my language, careful to make any pronouncement to void the new currency. To my mind, it is because if you look at the money expended.
But it voided it?
No, it did not void it.
If he said it was said it was withdrawn.
But he said that Naira design policy was invalidated,
yes,
because of due consultation was not done or made. How do you relate this? What could be the nexus?
That's what I want to speak about, or speak on rather. Okay. To my mind, I think they were trying to look at the economic aspect of it, the monies expended to produce the new Naira note. So if they go on to void the process, void the currency, where do we now stand? Where do we go? So in their wisdom, yes, in their wisdom, that's why I carefully use the language. They were careful in making their pronouncement on that aspect or on that issue with regards to the matters that came before it. But if you look at it, generally, the Supreme Court looked at the public interest. What will be the interest of the public in this matter? How does it go on affecting the public? What effects will it generate on the public? So the implications and all of this. So in their wisdom, they now came up with the judgment that we have seen just now. All right. So I think I agree with the judgment. However, like I said, there are some lapses still in the judgment. But we don't have any choice anyway.
Okay, let's see the relevance of this judgment. If we now see a situation where we are not able to see the old 500, old 1,000 naira notes, and what could be the possible sanctions that may follow, or what could be the reaction of this whole judicial process?
Thank you. If you look at the submissions of my colleagues, it boils down that the judgment was based on public interest. Okay. So it's a public interest litigation and not on grounds of original jurisdiction. And I will argue that to anywhere. But as I've said earlier, I said whatever we are doing here is post-mortem analysis and nothing more pretentious. It's a public interest litigation. It's on that premise that the court gave their judgment. Otherwise, if they actually have the jurisdiction to so void the process, they would avoid the policy itself. The policy has remained not voided.
But they voided the directive.
No, the directive is as to the timeline.
Okay.
Only elongated it. It was not voided. They only elongated it. The period with which you give is too short, considering the public interest. That's the judgment. Any other argument to the contrary may not address the issue.
But looking at due consultation, no, we
agree. I told you that even before even the National Council actually met. The position of the Supreme Court is the same as the Unitary Council position. They have given their position before. That one, they gave two indices. One, make the new naira notes available. The National Council, they met. And secondly, I say in the event that you are not able to make the new naira notes available, allow the new naira notes to coexist with the old naira notes. This position has been taken before now by the National Council, and I maintain it here when we discuss.
Okay, how do we galvanize?
Now the issue is
saying when we have a challenge where they may not be 500 or 1,000 old naira notes.
It is good to give a judgment.
Yes.
Enjoying the fruits of that judgment is another issue. That is it. Give a judgment. The question now is, the old naira notes, if you look at what our senior colleague said, they say they have been destroyed. It's there.
How do we authenticate that?
No. The truth is that the money by the CNBA policy have been withdrawn from circulation. That 500 naira and 1,000 naira note. They are not in circulation now. The question now is that will the CBA reissue that old naira notes?
But if an agency or an organization is saying that so notes have been destroyed, is it not upon the court to make that organization or agency produce an evidence to show that they were destroyed?
No, where's affidavit evidence? Because it was not a hearing. They come by regulating summons. I'm sorry, regulating motions also. So you do not bring evidence. It's affidavit evidence, opposed to which they presented in court. Parties were not by testimonies in court, cross-examined and all of that. That didn't happen. What happened was that they deposed to affidavit evidence to the fact that this thing you are able to ask us to resurrect. A person who is dead, you said he must be resurrected. It's no longer there. They deposed to such a fact. Now the question is that with the CBA now, the producing the old naira notes. That's the question.
And looking at the cost involved.
Yeah, so it's good to give the judgment.
Is it not producing the old naira notes? Why
don't people believe the new notes? It's good to give the judgment. The question is that how far and how best the citizens will benefit from the judgment is left to be seen.
It's good to know that this ruling, has finally laid to rest issues surrounding this saga of naira note scarcity as it relates to, the litigation we just had. Now, let's look at the way forward in terms of looking at an opportunity or the best possible way, to create a balance whereby even though we hear reports by the federal government that the old Naira notes have been destroyed, how can we cushion the effects that the Nigerians, the common man, everyone is faced with, side by side the ruling of the Supreme Court? Eddie.
Well, the beautiful thing is this: we do not have it authenticated that the 1,000 naira and the 500 naira notes have been destroyed. If they have, that's just one aspect of it. Yesterday, I was at the airport in Abuja. I was going to enter. There's this toll gate where you pay. The crowd that I was in said, Oga, do you have change? And I said, I have 500 naira. And I brought out the old 500 naira.
Oh, beautiful.
And he gave it to the guy who was collecting the toll. The guy picked it, and then when he was about to bring it, he said, Oga, we're not going to collect this one again. And he turned it. And I said, look, you have to accept it, because the decision as of today, maybe the decision had just been given like 2-3 hours.
Oh.
So, the truth is some Nigerians still have the old currency.
Good.
Yes.
So the idea, because right now, people are not accepting it, even when there was a pending injunction by the Supreme Court. That look, hold on, let the old and the new continue to coexist until the final determination of this matter. Then the CBN came out and said, no, we will 200, 500, 1,000, we are no longer accepting. And then the people took to it. And they stopped accepting it. It stopped being a legal tender in the field. So I can assure you that many Nigerians should still have the old currency.
So that can circulate.
So let it circulate. The ones they have not destroyed, let them begin to release them. Because at the end of the day, if the new Naira notes are not in circulation enough, then let the old ones continue to augment. That's what the Supreme Court have said. Okay. So for those who have it, who have not been able to use it, those who they believe have hoarded it, please bring them out. By virtue of the Supreme Court, if for instance that thing had happened in Benin yesterday, I can stand my ground and probably go to court to say, look, you have a duty, especially a government agency, to accept this money. If a market woman says, no, I'm afraid I won't take 500 naira from you, bring it to me. And then a government agency will not ordinarily have a business to say, I won't accept it in the face of the Supreme Court judgment. Okay. So for those who still have it, please release it into circulation. The ones that the CBN have not destroyed, if we are to believe them, let them release it into circulation. Because it was when the president said, bring 200 naira, that he brought out 200 naira. One would have thought, if the president had not given that directive, that, they too would destroy the 200.
Yes, of course.
How come you destroyed only 500 and 1,000 and the president was still able to say bring only 200? Why did you not destroy the 1,500 and 200 at the same time? So it's possible they just deposed to it, the money is still there. But in the face of the Supreme Court judgment, if they have it, they should release it. If they don't have it, those who still have it, the Supreme Court judgment has given the leverage where you can now continue to use the same.
Okay, let's take your reactions on that alongside your closing remarks.
Yes, firstly, as I'm seated here, I have 10,000 naira, the old naira note, 500. And the lady at the canteen, I gave her just now, she refused. She said she will not take the 500 naira. That now old money will not take this one again.
Because they are yet to see the response. And also, they are yet to see the response, interfacing the circulation aspect that we're talking about just now.
More so, let's look at the governors that went to court. Some of the governors, even in their state, they declared that the money is still a legal tender in their states. For example, Kaduna State. The man made a pronouncement that the old naira note is still a legal tender in my state.
So which means they've been enjoying a robust circulation?
Yes, the money is in circulation.
Okay.
And I think the Supreme Court looked at some of those evidence and came up with the pronouncement they did. So whether or not the federal government went to court, deposed to an affidavit telling the whole world that we have destroyed the 1,500 old 1,000 naira note and 500 naira note, that is not what will I call it now? It's not an evidence that the Supreme Court can rely on, that can convince the court.
All right, all right.
It was not an evidence that should convince the court. And the court, in their wisdom, were not convinced with that.
Okay.
So they looked at the public interest, and owing to the fact that some of the governors have in their own states pronounced that this money is still a legal tender.
Thank you so
so
much.
So on that ground,
Thank you so much, Barrister
Emmanuel
Obakpolo, and of course, Barrister Eddie Asenogwa and Barrister Sunday Daudu. Well, this is where we're going to lay this issue of NAIRA scarcity, the NAIRA note scarcity, to rest for now, as we've seen the report by the Supreme Court, and we hope to see much of these old and new notes, being circulated in order to reduce the economic hardship that the people, Nigerians, including us here in the studio, are faced with. Well, this is what you can take on this segment. We do hope you join us same time next week. I am Philip Omo Gyupon. Goodbye.